Good morning, everybody, and thank you for joining us today. As my colleague has just mentioned, my name is Yvonne Ewang. I assume that some of you will already be familiar with the conventions. So we will start off our presentation with a brief overview of the conventions, then go into more general steps of becoming a party with a particular focus on amendments and especially the ban amendment to the Basel Convention. So just going into a very quick overview, as you can see from this slide here, the three conventions were adopted and entered into force at different stages, with the oldest being the Basel Convention that was adopted in 1989 and that entered into force in 1992. Then followed the Rotterdam Convention, which was adopted in 1998 and entered into force in 2004. The Stockholm Convention was adopted in 2001 and entered into force in 2004. And you can just see there some of the figures for the number of parties to these conventions at present. So there's quite a large number of countries that have become parties to these conventions. And we just learned today that the Basel Convention will have a new party very shortly. So that number will also increase in the immediate future. Now, why are these conventions working together, and what do they aim to do? They have a common objective of aiming to protect human health and the environment from particular hazardous chemicals and wastes. In terms of the scope of the conventions, the Basel Convention covers wastes that are listed in its annexes. The Rotterdam Convention covers pesticides and industrial chemicals, and there are currently 43 listed under the Rotterdam Convention. And the Stockholm Convention covers a particular group of hazardous chemicals known as persistent organic pollutants, and that includes pesticides, industrial chemicals, and byproducts. The common thread between these three is that most persistent organic pollutants, or POPs, are covered by all three conventions. Many pesticides are also subject to the three conventions, and as wastes, all chemicals fall under the scope of the Basel Convention. Now, turning to the particular example that we're going to look at today of the ban amendment. The ban amendment addresses the prohibition of export of waste, and you can find a little bit more information on the Basel Convention website. We'll provide you with that address at the end of the presentation. But the ban amendment prohibits all transboundary movement from countries that are listed in Annex 7 of the Convention, which is members of the Organization for Economic Cooperation and Development, the OECD, the European Union, and Liechtenstein. So all transboundary movements of hazardous wastes from those countries to those not listed in Annex 7 are prohibited, whether that be for final disposal, but also for reuse, recycling, or recovery operations. Now, this is particularly pertinent because at the last meeting of the governing body of the Basel Convention, there was an agreement reached about the requirement for entry into force of amendments to the Convention, including entry into force of the ban amendment. As you can see up there, if you looked at Section A of Decision BC 10.3, which is also available on the Basel Convention website, you'll see the text of that agreement between the parties, which also encouraged parties to continue to take concrete actions towards encouraging and assisting parties to ratify the ban amendment. So this is a particularly important topic for the parties at the present time. As I mentioned at the start, we've just gone through the overview of the conventions very quickly, and we'll now look into what procedures apply to becoming a party to the conventions, and then also looking at the processes for amendments and protocols. There are general steps, but there are also convention-specific steps. And the backbone of the legal regime that applies to the conclusion, entry into force, application, suspension, and termination of treaties between states is the Vienna Convention on the Law of Treaties. Now, this goes wider than just the Basel, Rotterdam, and Stockholm Conventions. It also applies to almost all international agreements that are entered. And it gives a general framework for the procedures that are applicable and the legal regime that's applicable to those. Now, each convention has its own specific steps, whether that be the Stockholm, Basel, or Rotterdam Conventions. In order to become a party to a multilateral treaty, a state or what we refer to as economic or political integration organizations, and that could be, for example, the European Union, a state or such an organization must demonstrate through a concrete act its willingness to undertake the rights and obligations in the treaty. And that means that it must consent to be bound by the treaty. Now, at this point, I would highlight that the domestic procedures for expressing consent do vary from state to state. So what would apply in Morocco, for example, would not necessarily be the same as the procedures that India would need to go through. However, there are these general steps that may be applicable to a number of states. And these steps are set out in the treaty handbook that has been prepared by the treaty section of the Office of Legal Affairs for the United Nations, which is also the depository for the Basel, Rotterdam, and Stockholm Conventions. Each convention specifies what instruments a state can use to express its consent to be bound. The convention also specifies how a political or economic integration organization can express its consent to be bound, which are usually there are similarities or the same steps for both. However, it must be noted that consent to be bound will only take effect once the instrument has been deposited with the depository of the convention. To give an example, in some cases, the Secretariat has received instruments which unfortunately don't have the same effect as depositing with the depository. So it's important that that instrument is sent to the depository once the state has gone through the relevant steps at the national level. And once the instrument has been deposited with the depository, the state or political economic integration organization will become a party 90 days after the date it deposits its instrument with the depository. Now, before depositing its instrument, it's usually states go through a certain number of steps to prepare and to prepare for becoming a party to the convention. The first one would be preparing analysis or collecting documents. Now, this could include, for example, mapping what legislation exists, analyzing what are the benefits and implications of becoming a party, and balancing those with the costs associated with taking this step. After doing that, The information is shared with the authorities involved in these steps prior to and up to deposits of the instrument. And the authority who issues the instrument is contacted by the lead ministry, which could be a Ministry of Environment or another ministry involved in negotiating or implementing a convention. And this lead ministry will contact usually the legal unit within the Ministry of Foreign Affairs to identify what the national procedures are and initiate those processes. Once the processes have been initiated, the instrument for becoming a party will be prepared, and the necessary person to sign the instrument will be identified. In preparing the instrument, the state also needs to decide whether it wishes to make any declarations or statements. These will then be included within the instrument or an instrument of declaration prepared as well. And this will be signed at the same time. After that, the instrument will be deposited with the depository. And usually this is undertaken by, for example, the permanent mission of the state in New York. So what type of instrument is required? There are different dates for the Basel, Rotterdam, and Stockholm Convention up until which signature could take place. However, the types of instrument include ratification, acceptance or approval, and up until a certain date as mentioned before, signature. Presently, the main way for a state or organization to become a party is through accession. Now, when depositing the instrument, who can execute it? The state must execute the instrument of ratification, acceptance, approval, or accession, which is signed by either the head of state, head of government, or Minister of Foreign Affairs. Or in some cases, there are persons with full powers who are authorized to sign the instrument. Now, is there a form or format for the instrument? There isn't a mandated form. The treaty handbook that we mentioned beforehand does include models that states may wish to follow. However, this is not mandatory. Any instrument must include certain information, but the form or the format depends on the national legal and constitutional system. So what needs to be included would be the title, date, and place of the treaty concerned. So that could either be the Basel Convention, the Rotterdam Convention, or the Stockholm Convention. The full name and title of the person signing the instrument. And I'll recall that that has to be either head of state, head of government, or Minister of Foreign Affairs, or a person acting in that position with full powers. The instrument must also include an unambiguous expression of the intent of the government or the state to consider itself bound by the convention and to observe and implement the provisions. The instrument should include a date and place when the instrument was issued, and the signature of whoever is executing the instrument. So how should states or organizations deliver their instrument to become a party? As I mentioned earlier, the instrument is only effective when it's deposited with the depository, and that is the Secretary General of the United Nations at the United Nations headquarters in New York. Currently, the Office of Legal Affairs, which is also based in New York, acts as the depository on behalf of the Secretary General. States are advised to deliver these instruments directly to the treaty section, and where feasible, it's also a good idea to provide a courtesy translation in English and or French. which facilitates prompt processing of the relevant actions. Now, we mentioned before declarations or statements. Can states make declarations, reservations, or exceptions to the conventions? None of the three conventions we're talking about today allow for reservations or exceptions, but a state can make a declaration, whether that be an optional declaration or an interpretive declaration. An example of an optional declaration would be where a state agrees to submit any dispute to the International Court of Justice or to specific arbitration procedures that have been agreed by the parties under the conventions. And just a reminder that of this need to deposit the instrument with the depository. You'll see just in front of you the United Nations Treaty Collection website. And you may wish to have a look around that website. It's treaties.un.org, and that provides you not only with the treaty handbook, but information about the depository practice, for example. So just to summarize, what needs to be done to become a party to the conventions? There's a lead authority who prepares analyses and documentation to look at the benefits and implications, as well as associated costs of becoming a party. The information is shared with government authorities responsible for issuing instruments to become a party. The appropriate steps are identified, and the necessary documents or processes are completed. So following this, the instrument is signed and deposited at the depository. And 90 days after, the convention will enter into force for that state. Now, turning to amendments. For amendments, there are also general steps and also specific steps for each convention. The general steps are also covered by the legal regime under the Vienna Convention. Which provides that any treaty may be amended by agreement between its parties. And when we talk about an amendment, it means formally altering the provisions of the treaty. And we'll look at an example of the amendment to the convention, the Basel Convention, the Ban Amendment, a little bit later on. Every party to the convention is entitled to participate in the negotiations of an amendment to that convention. And following an adoption of any amendment, a party may express its consent to be bound. Once an amendment enters into force, it will bind only those parties that formally express their consent to be bound. According to the Vienna Convention, when a state becomes a party to a convention that has undergone amendment, it becomes a party to the convention as amended. So that means that if there's amendment adopted to the convention that then enters into force and a state becomes a party afterwards, it doesn't have an option of expressing its consent to be bound by the amendment. It is assumed that it becomes a party to the convention as amended. And as mentioned before, there are specific steps within each convention that are contained for the Basel Convention in Article 17 of the convention, and for Stockholm and Rotterdam in Articles 21 of each convention. So what is the procedure for expressing consent to be bound by an amendment? Now, as mentioned before, any party to the convention may propose an amendment, and that also applies for protocols. Currently, neither the Rotterdam or the Stockholm Convention have protocols. However, there is a protocol on liability and compensation under the Basel Convention. There is a process for making these proposals, which must be adopted by meetings of the governing bodies, the conferences of the parties. And the text must be communicated at least 6 months before any meeting of the COP. The steps prior to or up to deposit of an instrument and on deposit of an instrument are very similar to those that we just went through for becoming a party to the convention itself, although there are specific procedures for adoption and amendment of annexes. So this was a very quick run through of the procedure for amendments. And to summarize, for amendments, we have the proposal that can be made by any party to amend either the convention or protocols. And for the protocol, it would have to be a party to the protocol that makes the proposal. This proposal, which is communicated initially to the Secretariat, is then passed on to all parties to either the convention or the protocol. It's discussed at a meeting of the Conference of the Parties, negotiated and potentially adopted, depending on the final decision of the Conference of the Parties. And then the parties at the time express their consent to be bound or not to be bound. Those wishing to be bound by this amendment prepare and deposit their instrument with the depository, and there we go through the steps of preparing analyses, collecting documentation, national consultations that we went through just a minute ago for being a party. The instrument is deposited at the depository, and the amendment also applies to that party. And then there's the procedure for those states that become parties to an amended convention after the entry into force of the amendment. And those new parties are bound by the convention as amended. So there are similarities in the procedures applicable to conventions and to amendment and the processes relating to amendments of the conventions or a protocol, but there are differences in the procedure. There will be further information available on the Basel, Rotterdam and Stockholm websites very shortly, as well as circulated to participants of this webinar. So it would certainly help to have a look at that in a little bit more detail, because each convention does have its own specificities. And unfortunately, due to time, we don't have time to go through each of those. But the idea was to give you a general overview of what procedures exist, what amendments exist, and the processes that relate to the consent to be bound by those amendments. So thank you for your attention. And as you can see here, there are the three websites for each convention. Please feel free to have a look at those, and further detailed information will also follow to participants in the near future.